Hi again, everybody. Hopefully, you just watched the opening lecture. Hopefully, you've gotten some practice drafting an opening and seeing what some of the best have to offer. But now it's time for the closing argument, the last word in the trial. You've heard the opening, you've heard all of the witnesses, and it's time to sum it up and end strong. So I'm not going to assume that you know what closings are. We're going to discuss the best way for us to strategically approach them. And just like with the opening, remembering the primacy and recency rule, we've remembered the first thing and the last thing better than what happened in the middle. You should start very strong on the closing argument. So remind us of our theme. And after giving that theme once again, you can either tell the narrative again, what is basically what happened in the case according to your side, or you might launch into an analogy. I'll give an example of this. I saw a very talented appellate attorney give an analogy where he said, recently, my wife and I went out for a nice Italian dinner. We ordered something, waiter took back our order, the door was closed, and we couldn't see into the kitchen. We waited. They served up a meal. Meal looked good. Meal tasted good. But I had no idea what the ingredients that went into this meal actually were. And I think the same thing about the prosecution's case today, because they haven't showed you how their meal was made. It was our job today as the defense to strip away all of that lack of transparency, to open up that door to the kitchen, and to show you the truth. I thought that's an interesting analogy. But if that isn't true, if that doesn't speak true to you, if that doesn't work for you, then you might choose a memorable moment in the trial. Ladies and gentlemen, I want you to remember what happened during the cross-examination of the defendant today. This was an aggressive defendant. As I questioned them time and time again, they kept refusing to answer the question, denying, desperately denying. That's not a surprise, ladies and gentlemen, because that sort of desperation is exactly what has put this defendant in court today. Their desperation both on the stand and at the incident at hand. That behavior is what's going to make sure that you convict them of the murder. So you can connect what's happening on the stand to what's happening in the actual case. It's a clever way to connect that. After that, you want to remind us of the charges and your burden of proof. There are elements that you have to prove. It's not enough just to tell the story. You have to say specifically what you must establish. So in a drunk driving case, there's a legal limit for what it means to be drunk. You should remind the jury of what that is so that they'll have an easy time making their decision. And then you want a roadmap. Talk about what you're going to say before you actually say it. Additionally, in the main body of your speech, after you've started really strong with the theme and then the analogy or the narrative or the clever moment, you've talked about the burden and the charges and you've given a roadmap, you have to use the main body of your closing to explain the significance of the important facts. It's not enough just to say the defendant told you this or they admitted to that. Tell the jury why it matters. Tell them what weight they should assign to this. So for instance, the defendant admitting in a drunk driving case that they knew they were tipsy when they were driving, that's something that's pretty powerful because it shows they had knowledge they were doing something wrong and they did it anyway. But it's not enough just to talk about the important facts for your side. You have to expose the weaknesses for the other side. Because if you're on the prosecution, you know the defense has gotten up throughout the trial and tried to talk about doubts, but maybe their logic doesn't make sense. Or maybe they've tried to raise questions, but there's no evidence to support their questions. After you give your facts, compare them to the other sides and show how they're lacking. You should remember, of course, that it's only the plaintiff or prosecution that has the burden of proof, which means you can't get up as the plaintiff or prosecution and say the defense has failed to prove something. It's not their job to prove it. It's their job to raise doubt. As far as tools of persuasion, a lot of what we talked about in opening still applies. Simple language, repetition, triplets, primacy and recency. Using rhetorical questions can be useful as well. There was a case about whether a scuba diving company was negligent or not for letting a diver who was struggling dive incredibly deep, and then that diver went off and died. So, a very effective plaintiff closer decided to list all of the things that the defense knew that the company permitted before the death occurred. And he used rhetorical questions. He said, in what world do you see one of your own clients struggling to breathe and think that's okay? In what world do you ignore the concerns of your own staff about that struggling diver? In what world do you break industry code to dive deeper and deeper and deeper when you see all of the signs of struggle? In what world is that okay? You, the jury, have the opportunity and the obligation to hold this defendant responsible for their negligence. So as you can see, it can be effective to use rhetorical questions at some points during your closing. And again, visual aids. Visual aids are good to make people follow along with what you're saying. In closing, especially if you want to be a big dynamic closer and it's online like this, the majority of the screen is taken up by the visual aid. So consider how it looks to your jury and make your strategic choice appropriately. Some techniques. First, remember the rule of three. We already talked about this in opening. Plaintiff or prosecution should try and fight for the three most important facts that prove the defendant's guilt. The defense could talk about the unanswered questions in this case, or questions that raise doubt, as in they're not unanswered. You, the defense, can answer them, and they show how the plaintiff can't prove their case. In closing, a lot of the tone, the ethos, the emotion is something that your judges will respond to. So the plaintiff or prosecution should always humanize the victim. The reason that we're in court is because somebody has suffered in some way. And all of us feel a desire to achieve justice in this case. So in a murder case, sometimes you'll see the prosecution in a mock trial hold up a picture of the victim and say something like, this was so-and-so. They were going to college, had friends, family, loved ones. They were thriving. They had their whole lives ahead of them. But we're in court today with nothing but their picture now, because this defendant didn't see them as a person. The defendant saw them as a problem. And that's why the defendant took matters into their own hands and took the life of this poor, sweet, innocent person. Notice how I keep calling the defendant. I don't call them by their name. I don't say, that's Mr. Hoyenga, that's Mr. Hill. You might do that a little, but generally you want to dehumanize the defendant. Calling them defendant as opposed to Mr. So-and-so, especially not their first name, is an effective rhetorical tool to do that. But additionally, the prosecution or plaintiff should paint the defense in a particular way. The defense is just full of desperate people making excuses. They're here for the sake of their own egos. They're here to make a quick buck. And that's the kind of tone that you should communicate. It is improper for you to directly attack the defense's character. You're not going to call the other attorneys bad people, but you can allow yourself a little bit of righteous indignation, because that can communicate to the jury, we're telling the truth, and we're angry or passionate for the right reasons. They're just trying to hide things from you, and that's not right. And the final tone that you have as the prosecutor is, if you don't agree, this is a green light for bad people to do bad things. But with your verdict, you can send a message. You can say, enough is enough. The defense, on the other hand, they should try to humanize the defendant. So you would never call your client the defendant. You would say, Mr. Hoyenga, Timothy, The more you do that, the more they might start seeing this person as just somebody like them, someone who made a mistake, somebody who is here under false charges. The case is overcharged and under investigated. This is about a rush to judgment. This is about a miscommunication. This person is here and it's a mistake. But you, the jury, can set it right. There's a story that was told about an attorney because the prosecutors often say, we're here on behalf of the people. So in the name of some of these case dockets, it could be people versus Hoyenga. So what the defense attorney said is, the prosecution keeps saying they represent the people of the state. But we, the defense, we do as well. We just represent them one at a time. A way to humanize your client. As the defense, you want to paint the prosecution or plaintiff as being irresponsibly corrupted by grief. They're the ones who are focusing on the emotion, not the evidence, the feelings, not the facts. They're not considering all of the different possibilities at play here. And that bias is blinding them. They are blinded by the need to blame. The role of the defense attorney is crucial because without it, people can be falsely accused, guilty until proven innocent. An un-American system, and you, the defense, stand up for our sacred, constitutional American rights. That's the tone you're going for on the defense. Let me give you some examples of themes. Here's some themes from the prosecution or plaintiff perspective. Again, prosecution is a criminal case, plaintiff is a civil case. Criminal case. She planned, she poisoned, she profited. I love these triplet themes because you can use them for the three main body paragraph of your case. You'll say it as a theme, and then those will be your 3 points. First, you'll hear how she planned, then how she poisoned, and third, how she profited. Another one, the defendant's words give them away. This is when you have a case where the defendant said a bunch of very damning things. For example, in the drunk driving case, if the defendant says, "Why did I drive when I knew I was tipsy?" And you add on quotes to that. "Let's see how fast this car can really go. I'm not slowing down for anyone. I could have more drinks." Just imagine you have quote after quote after quote. You could have your theme focus on that. Third, a Mustang, a message, and a mark, very similar to the planned, poison, profited. Civil cases where in mock trial it's often one individual blaming a corporation for being irresponsible. They sent her alone. They sent her to die. Good parallel structure. They were supposed to be the professionals. Simple, clear, puts the responsibility on them. They put profits over people. And then for the defense, close enough isn't good enough, a classic theme. This shows that the plaintiff, the prosecution, they were blinded by the need to blame. They got up there, they looked at the defendant, they thought, that's close enough. Let's charge them with this crime, but close enough isn't good enough. This is a case about unanswered questions. This is a case about a rush to judgment. In civil cases, maybe when you're trying to put the responsibility on the person who's suing you, as opposed to yourself, she was willing to take the risk. One diver didn't follow the rules. Or if you're saying there's an alternate cause of death, it wasn't the coach, it was the cocaine. That was a very interesting case where the question was, did somebody practice to death a sports player because they just couldn't stop because the coach was forcing them to go to session after session? Or was it an alternate cause of death? Maybe they were hopped up on coke during this time and that caused other medical complications that the coach had nothing to do with. All very interesting, very compelling, and I hope this has given you some more inspiration for your closing arguments.